So you have gotten a loan modification from your mortgage company. Typically, they'll give you a temporary one to see if you can make the payments on a trial basis, and then they will provide a final one. If you get your loan modified, that's great, but there's some procedures that have to be followed in bankruptcy court. And this is required. It's not an option that you have. So if you get a loan modification, the first thing you need to make sure that you do is you need to get my office a copy of the final modification, the one that you have executed that has the final terms. We don't do this for a trial modification because you may not make it, to be perfectly honest. We only want the final one. Once you provide that, we have to file a special motion, and it is called a motion to incur debt for loan modification. Because when you're modifying a loan, guess what? You're actually incurring some debt. So because of that, we have to file this motion, and we have to attach a copy of it so the court can sign off on it. If you don't do this, this is in violation of what you've agreed to in your case, and your case can be dismissed. So don't think you're just going to get a loan modification, not tell your attorneys. Eventually, it will come out because the lender actually has to push for this to be filed because they have to be in compliance too. So if you are working on a loan modification, you need to let us know that. Now, here's the other part of it. A lot of times clients will say, hey, I got my loan modified, so now all my mortgage arrears that I was paying through my case, that's wrapped into the loan modification. I want my payment lowered. Well, maybe we can do that, but maybe we can't, because remember, everything in bankruptcy is based on your budget, and you had a budget that was showing that you were making these payments with the arrears in your plan. So a couple of things have to happen. Number one, you have to provide our office, you and your spouse's most current pay stubs. And I need pay stubs usually for the last 90 days to show what your current situation is. Because whenever we make a change like this, the trustee is going to ask for it. And the judge is going to make you provide it, so don't whine about it. You have to provide it, okay? You have to provide proof of your income. Now, of course, we also understand that expenses changes. I mean, we don't even want to talk about inflation right now. So your budget when you started the case may be very different now, and that's fine, but we need to show it. This is a court of law. It is all about proof. So you can't just tell me things are different. I need you to show me. So if your mortgage payment is now going to be higher because the loan mod will show that. If your car insurance is higher, if you're spending more money for food, all of these things, yes, we can adjust your budget, but you've got to prove it. So for some folks, they'll say, you know what, just leave the payment the way it is, because they may be in a case where they will just get out of their case faster. And they're like, cool, I'll be out of bankruptcy faster. Wonderful. Other people are like, oh my God, the payment's killing me. I need it to be lowered. We may be able to do that. But again, we have to go through this process. So it's not just, oh, this is out and we're going to do this. There is a process. So you need to respect the process, and you need to listen to us when we're telling you these things need to be done. One of the most ridiculous things I ever hear or see from people is they'll say, oh, well, I'm just going to dismiss my case. Why? Why would you do that? You've already filed. It's already on your credit. You're already going through the process. Honestly, that is like the dumbest thing I ever hear is, I'm just going to dismiss it because I don't want to mess with it. That is the laziest, dumbest thing I've ever heard. I have rarely, I can't even think of a reason why you would want to do that. You've already filed. Cat's out of the bag. You're already going through the process. So just be patient, follow the rules, and listen to your attorneys. It amazes me that people, and I always say this, why are you hiring us to give you legal advice in a field that we've been practicing in for 24 years, and then you don't take it? You don't listen to it. My favorite is, well, I read this on the internet. I don't care what you read on the internet. I've been practicing here for 24 years, and I'm telling you, I know the judges, I know the trustee, I know what they're going to tell you. So just listen to your attorneys, listen to them, and follow the rules. That is why you are paying us. At the end of the day, I can't make you do something. All I can tell you is these are going to be the consequences of your actions. So if you are going to modify your mortgage, cool. Let us know. We're here. We're going to hold your hand through the whole process. I'm seeing a lot of loan modifications for clients, which I think is great. I'm a relic from, I remember the 2008, 2009 drama. And so I really, we've seen lenders honestly step up. They've streamlined the process tremendously. Trust me, tremendously from what happened in 2008. So if you have any questions about a loan modification, and you're one of my clients, of course, reach out to us. We do have on our website, we make it super easy. When a client gets a final loan modification, not the trial, when they get a final loan modification, all you have to do is go to the Chapter 13 client portal, which is on our website. You should have this bookmarked if you're a Chapter 13 client. Actually, if you're a 7 client too, you should have it bookmarked. But go to this page, scroll down, and you will see where you will submit you'll put your information in, and you will submit the actual executed loan modification. Don't email me. That's not our process. And we have processes in place so that the right people are processing your file accordingly. So again, follow our procedures so we can make sure nothing gets lost in the shuffle, that it's processed correctly. However, we have to have the executed loan modification. So if you don't have it, there's nothing to do right now, okay? So you can email and tell us you're working on it. That's great. If you have a question about it, that's fine. If you think it's a good idea or bad idea, of course, we can review that with you. But we can't file anything until we have the executed loan modification final. So just make sure that you go to our website, follow the instructions, and upload it, and we'll take it from there.